Well, good afternoon, everyone. Thanks for joining our Legal Live. We've really enjoyed having these Q&As and reaching out to everyone, and appreciate everyone that tunes into this. As you probably are well aware, we sent out an email earlier today, and we notified everyone of what we were going to be discussing in advance, and we're going to be discussing some changes to some existing forms. And we have a special guest with us, Shane Norris. He is general counsel for Summit Sotheby's, and he is also our forms chair. And he's also the forms chair for Park City. So he wears a lot of hats. Thanks, Shane, for joining us.
My pleasure. Thanks for having me.
And we also have Lance Harrison. Lance Harrison's legal counsel here at the UAR. We're glad to have him. And I'm Craig Wagner. I'm kind of your host, so to speak, for this Legal Live. So I want to first dive in to some of these changes. I'm going to attempt to share my screen and highlight. Let's see, and highlight maybe the first change. And so we didn't do any changes to the exclusive right to sell listing agreement. I know I have this as a form here. But the reason why I'm highlighting this is that we made a change to the addendum to the exclusive right to sell listing agreement. And you'll notice in this form, this agency agreement, it references a generic data form. Maybe Lance, we'll start with you. The data form, what kind of is the purpose behind the data form? What does it serve?
Yeah, I think it's mostly for the MLS, and then also for the listing agent and the seller to be on the same page about data about the property, right? And so that they can discuss the things about the property itself, and then be on the same page about how they want to go forward marketing that property in different ways.
Yeah, and you'll notice in section 1, it talks about how the list price and term stated in the attached data form, it's part of the agreement between the seller and certainly the listing brokerage. And the data form is incorporated by reference, not only here, but other areas within the agency agreement as being part of the listing agreement. So when we look at, I'm going to pull up the addendum. Shane, we added 3 words to this addendum. Okay, we really went all out. So if you see on the various platforms or vendors that we utilize, and they say that, oh, a new change has been made, this is what we added to this. So maybe you can explain kind of the rationale behind why we added this language to this addendum, and maybe the purpose that it serves.
Sure. This is you and I spent way too much time making a change where there's 3 words involved on it.
Right.
But the problem was we were having questions. UAR was having questions. I was having questions. All the brokers are having questions as to how do we make a change to something very basic, such as the list price on the property. And that's the normal change. We want to increase the list price. We want to decrease the list price. What form do we use to do that? And a lot of brokerages say, just send me an email. A lot of brokerages say we need to do an addendum to the ERS. Some of them say we need to go get the data form and do a new data form, because that's the only place where it actually has the purchase price related to the listing agreement. And so our initial concept was, do we need to do an addendum to the data form so they don't have to keep using that same form over and over, where there may be one small change that's going to be made and you have 27 different items on there. But because the data form, as you just pointed out, is already incorporated into the ERS, it didn't make sense to have an addendum to something that essentially acts as an addendum already. And so the simple way that we ended up dealing with this issue, after many conversations about it with the forms committee, was just to incorporate the term data form into the addendum. So it's changing the data form, but at the same time, it's clear that it's amending the ERS, which the data form already did.
Yeah, so if there's any sort of deviation from the listing agreement, the boilerplate language that the UAR has, or the data form, this addendum is going to control. So it's really just lumping them all together, saying, look, if we make any sort of modifications, which, like you mentioned, a change to price is probably going to be the most common, then this is going to control. The new price is going to control. Why, maybe I can ask both of you, why would you want to have the seller's signature and authorization to change something like purchase price?
Yeah, I'll say just really quickly, it's just safe, right? It's just smart to have something in writing that tells you and puts everybody on the same page about something important like the list price, especially if you already have a data form that's signed with the listing agreement that has a list price. If you're changing that, so then the price is going to be different on the MLS than the data form, then if who gave you that authorization, or was there a conversation, was there not? If the client maybe brings up an allegation of any time that you're misrepresenting the property or misrepresenting a price that they had agreed on, you want all those changes in writing just to protect yourself, I think, and to make sure the client is on the same page as you.
Yep, exactly.
Well,
Shane?
and there's also incorporated in the listing agreement is language that states that it can only be modified in writing. And so if you have a data form that states what the list price is going to be, the MLS may allow you to make a change, but technically you weren't allowed to do that without having it in writing. And so we've seen complaints with the division before where agents have been fined because the division found that they didn't have authorization to change the list price when they did so. And I haven't been involved in any of those complaints, but I'm guessing the issue was that the agent had been told by the client, change the list price, go ahead and lower it, but they had never actually memorialized that in writing. And so they didn't have evidence to prove that they had received that authorization. And the division, when seeing no evidence and having a complaint that they didn't authorize it, they're going to look at our forms. And our forms say it has to be in writing. And so we've seen agents fined before because they didn't have a change in the list price in writing. The division found that they didn't have authorization. And I think the way the division found that was they didn't have written authorization, which is what our contract requires. So this makes it easier to get that written authorization. There's other ways to do it, but I think this is going to be the cleanest way for an agent to get changes to the data form done correctly in a very simple way.
Yeah, I agree with that. And we're having some comments of, well, what data form are you talking about? It's a generic term. When we look at the exclusive right to sell listing agreement, it's really just the property data form. And because there are a variety of MLSs within Utah, we're not naming it just after what utahrealestate.com says, or Park City says, or Washington County. It's just a generic term. So we are referring to the MLS data form or the input form that you're utilizing to list the property, but it's just a generic form. So we refer to it in the addendum as the data form because that's what we refer to on the exclusive right to sell listing agreement.
Right. And that could be created by a brokerage as well. It's really
Yeah.
any form that you're using to add additional information, such as the list price. And you could have the amount of bedrooms, the amount of bathrooms, the square footage, all of that could be included in the data form, and different MLSs do have that. But a brokerage could create their own as well. And that allows for flexibility. If the Park City MLS has one form and the St. George MLS has another, and WFR doesn't have one or does have one, this allows flexibility that this can be used universally throughout the state of Utah, with or without MLS forms or a brokerage form. This allows everyone to have their own version of it that would be appropriate under these circumstances.
Yeah, excellent. So it looks like there's some commentary about the MLS change form, and I think that's in reference to utahrealestate.com's removal of the change form. And the answer would be yes. This is in part due to the questions that we've received, that Shane's received, about, well, the change form I would have my client sign, and that could modify purchase price, and I don't disagree with that premise. This form, because there's no longer a change form on that particular MLS, does make it sufficient to modify purchase price or any other term found within the exclusive right to sell listing agreement. So those questions about that's in reference to that.
There were a lot of questions about the change form, and did that actually modify the listing agreement? And I know there were discussions inside WFR about modifying their change form to include language that could make it so it amended the listing agreement, because it really was being used a lot to modify the listing agreement and changes in there. I wasn't involved in the decision to remove that form, but I think there was a problem with that form, whereas the question was, does this actually modify the listing agreement in the way that it needs to be done? I would say it did. It was in writing. It generally was signed by the client, but there still was, it didn't exactly spell that out, and so it created a lot of confusion in the industry.
Yeah, exactly. And that's the whole point. We want it to be as clear as possible. There's some questions as to whether or not getting consent and authorization from the client via email or text message, would that be sufficient in your opinion?
Yeah, so Utah hasn't litigated this issue yet. And this really goes to electronic signatures, because when we talk about how we make a change to a written contract, when it has language that requires that to be in writing, that means it's going to need to be signed. Almost all cases, in fact, I would say all cases I've seen come out of other states, and I'm confident that Utah would have the same rules, because basically electronic signature statutes are the same in state to state and federally. It has to be modified in writing. It has to be signed by the parties. So an email in almost all states is being found to constitute a written document that has an electronic signature attached to it, and they base that on your name at the bottom of it, or potentially in the signature block at the bottom of it, or even in your email address at the top of it that usually contains a name. And so if it's clear that there's a name on it, usually I would say that absolutely can constitute a written agreement. The problems become, though, if it's only one-sided, did you need the other side to sign it? But if you have an email from a client saying change the price, and an email from the agent saying you got it, I'll make that change, I would say that's probably going to cover it under the terms of this. Text messages, that hasn't been litigated yet. There's questions of whether or not there's an electronic signature associated with a text message. So I personally advise our agents not to rely on a text message, but an email will accept a change to purchase price and things like that in my brokerage based upon an email, because I'm confident that that actually can constitute a written change to an agreement based upon an email.
Yeah, exactly. And here's where it talks about, this is in the exclusive right to sell, section 16. The very last sentence is exactly what Shane's talking about. Signed, and you're right, this idea of electronic signatures and attribution through emails, I think is becoming more and more clear. If you want to err on the side of abundance of caution, then you get it signed either through electronic signature or ink signature.
Yeah, and I think you want to make sure that if you're getting something in an email from a client authorizing you to do something, just make sure that their name is on it, and that way you can claim this is an electronic signature. I think you're going to be fine either way, but most of the case law is referring to their name actually on the electronic communication as constituting a signature.
Right, exactly. Anything to add on these points, Lance? Any considerations or concerns?
Yeah, well, I'll just say that as I listened to the committee talk about this, it was really cool to see them go through a couple more complicated ideas and end up with a really good, simple way that's easy to understand that applies to everybody. So I think it's a great change.
Yeah, we had iterations, just for those of you that weren't part of the discussions. We had iterations that in essence was an addendum to the data form, which was an addendum to the exclusive right to sell. So you just kind of had tertiary levels of addenda, and it gets too complicated. And I agree with what the committee ultimately settled on, which is changing 2 words or adding 2 words to the exclusive right to sell listing agreement addendum. And so I'm in full support of that. So I guess there was a question. So the change form is no longer available for off-market status. So changing the status of the marketing, what would you recommend that agents should do if they're going to change the status on a particular MLS?
So I do recommend that agents use addendums to the ERS to determine what type of marketing that is going to be done on there. You can use the MLS forms to do that. Again, most of they're going to be in writing. They're signed by the client. But anytime that we talk about how we're going to market a property and restrictions we're going to put on it. So we're not going to go live on the MLS. We're only going to be marketing as an exclusive office listing. I think you want to make sure that that's spelled out in your contract so it's clear that your client understood it and agreed to it as well. So any type of marketing changes that you're making that are outside what a standard ERS would say, I always recommend that that be done through an addendum, so the client doesn't, number one, so there aren't any misunderstandings. It's easy for Craig and I to have a conversation about what we want to do, but often, people walk away thinking that one thing was said and another person thinks that another thing was said. And until you actually put that in writing and make sure it's clear to everyone, there can be misunderstandings that take place. So that, along with the ERS says that you're going to do these 7 things, and it includes putting it on the MLS. So if it's not going to be on there, or you're going to be doing other types of marketing, absolutely put it in an addendum.
Yeah, it's just making it so there's no equivocation, because every agent has seen this in negotiations of contracts and representing their clients, where initially everyone's on the exact same page, but as time goes on, there could be a difference of interpretation of that previous conversation, or the language that was used in a contract. And so that's why you want to be as clear as possible to avoid the pitfalls in the unlikely event there's any sort of litigation or accusation of breaches of fiduciary duty.
Yeah.
One of your clear fiduciary duties for all agents is reasonable care and diligence. And in my estimation as an attorney, it's frankly your broadest fiduciary duty that you owe to your clients. So showing that you have everything in writing, that you have a paper trail of your actions and why you're doing certain things, I think illustrates how you're meeting that fiduciary duty of reasonable care and diligence.
Yeah, and I have current ethics complaints right now on these issues of just not being clear agents with their clients. And so the client later on, as time passes, they get more and more upset about not knowing exactly what's going on or how it's being marketed. And that communication kind of breaks down, and it ends up in complaints or division issues or ethics issues. So
yeah, sure. I've dealt with a lot of ethics complaints and division complaints over the years, never with Summit Sotheby's, always with other brokerages. But it's, the need to go back through 100 pages of emails and text messages to be able to prove that, yes, the client did authorize to do this. It's effective, but it's incredibly easy if you just have an addendum to the contract to be able to prove, yes, this is what we agreed to and this is what we decided on. When you have to go to 3 other sources to try and piece that together, and then potentially be in a place where you actually don't have any written evidence of it, that's scary going into an ethics complaint when you don't have that type of ammunition. Whereas if you just would have had the addendum done at the beginning when everyone still loved each other, that's the best feeling, walking in and being able to just slap that down. Whereas piecing together 3 different emails and text messages that all took place around the same time and say, this came first, this came second, this came third, to show that this communication took place, that's just a lot harder for a committee to look at and understand, or the division to look at and understand.
Yeah, so it's just elevating the level of professionalism. I completely agree with both of you. Okay, excellent. So I appreciate the dialogue, everyone. Excellent commentary and questions. We're going to shift gears to a form that's been completely transformed. It has a new name. It has obviously new language in there, and so we want to kind of introduce it. So let me go ahead and share my screen again about this. Let me see if I can make it a little bit easier to see. Oh, okay. Okay, everyone see that? Okay. Zoom in a little bit. Okay, so let's start before we even jump into this. The name is now the subject to seller securing replacement property. It's not a mandatory form. It's not something you have to do, but it is another tool that realtors can use, and it's a value proposition. Before we jump into the form and its contents, maybe Shane, you can give us a little background as to why a form like this may be necessary in a seller's market, especially in a seller's market where there's low inventory.
Yeah, so this form used to be called subject to seller purchasing or subject to the seller purchasing a new property, something like that. But the concept is the seller is going to have a contingency that allows for them to cancel the contract if they can't find another property that they want to move into. And, I don't think I ever heard of this addendum. Craig, you and I have been doing the forms committee for a long time, ever since you and I've known each other. Lance is, he's a baby, he's come into it. But I'm not sure you and I had ever even had a conversation about this form until probably 3-4 months ago, when the market was hot, but the market absolutely exploded. And the problem was there's not enough inventory out there. And so sellers were nervous about selling their property if they didn't know that they had another property to move into or to be able to purchase. And so we started to get calls from agents about, hey, what do we do? My seller wants to make sure they can cancel if they can't find a replacement property. And there was a form out there, but when we looked at it, I'm not sure it had been modified, Craig, since you were born. It definitely hadn't been modified since Lance had been born. And when we looked at this, we found that it had some conflicts in language, and it didn't really accomplish what we wanted it to. It basically had language that once the seller found a replacement property, went under contract for a replacement property, the contingency could be argued essentially ended at that point. And that wasn't what most sellers needed. They wanted to be able to go through the process to make sure that they could walk away if they needed to. And so the changes that we made and completely modifying this and even changing the name of it is all based upon, we want this to be clear what's taking place. The seller needs to find another property. They want to be able to determine whether or not that's the property they want to purchase. So they need to get through contingencies, things like that. So that was the impetus behind this form, and why we thought it was important to change it. And I think it's a great it's a great substitute for what we had before.
Yeah, and I'll just add one thing. I have been floored by the number of calls I've received from listing agents saying my seller has gone under contract and they now have seller's remorse. They want to back out and they don't have an out to do it. And so they're in essence saying, we're willing to breach our contract and face the consequences found in section 16.2 of the REPC for seller default. And so it's something that's reoccurring over and over on the hotline, at least these last couple of months. And so it is a way to kind of shift the pendulum, because the REPC is very buyer friendly. I mean, I think we all understand the outs that a buyer has. This, in essence, creates, if agreed to by both buyer and seller, an out for the seller in order to cancel. And this does replace the subject to seller acquiring new residence addendum that we previously had. So let's walk through this language of what it does and why we have it. So maybe we'll start with section 1A, Lance, and really kind of go through this and what is the consequence of what we're creating here in 1A.
Yeah, for sure. So it's a great form, and it's actually quite simple at its core, even though it might look 3 different paragraphs a little scary, but it's pretty simple, and it just gives a pretty broad out for a seller, just like Craig said, before this deadline in 1A. So let's go through it. Seller's obligation to sell the property is conditioned, the subject to seller securing replacement property conditioned upon seller entering into a contract to purchase or lease a replacement property. So let's just stop right there and just say this goes back to what Shane was saying about getting a property that they can move into. It's not necessarily purchasing a property, but it's getting a property that they're okay with to move into so that they can move forward a little bit. So that's a little more broad than it was before. A replacement property and being satisfied with the replacement property's physical condition, appraised value, or financing by 5 on a certain date. And again, that's how broad it is. It's basically an open-ended out for a seller anytime before that deadline for basically any reason. I think you can argue a lot fits in those conditions there. So then we get the deadline there. So before then you have an out. Then seller, in seller's sole discretion, may remove the subject to seller securing replacement property condition at any time prior to the replacement property deadline, providing written notice to buyers. So if you want to negotiate that or something, you can remove that as part of future negotiations. But that's the basic contingency right there in 1A.
Yeah, so from a practical standpoint, I mean, you're creating a replacement property deadline. And I understand the concerns a buyer may have in agreeing to this language, right? They're going to see that replacement property deadline, and they're going to look at the deadlines within the REPC and say, okay, is this going to come before or after my due diligence? Am I going to spend money on an inspection only to have the seller cancel the REPC because they couldn't find a replacement property? And those are all valid points. So ultimately, this deadline, whatever it is, whatever the two parties negotiate, you're going to have to look closely at the other deadlines within the REPC, and make sure it makes sense for both the buyer and the seller. Certainly in a seller's market, the seller may be in a position to dictate the terms of this replacement property deadline to make it a little bit further out. But it is going to be a negotiation. I mean, I don't anticipate this being a super long deadline in most instances, because the seller is going to say, look, I want to test the market. I have some properties in mind. Hopefully I can do a quick inspection and secure this buyer that I'm hoping to have under contract. But again, that's a point of negotiation between the buyer and the seller as to what exactly this deadline is. And shifting to 1B, as Lance somewhat alluded to, maybe Shane, you can address this. This is the seller's right to cancel. So notice the language and notice how different this is from the previous iteration of the seller's subject to seller acquiring an interest in or acquiring a new residence addendum. So what does 1B do, Shane?
So your key anytime you're seeing cancellation language, particularly in our forms, it's in the party that has the ability to cancel. It's in their sole discretion. What we want to make sure when we're creating these forms is not only are they understandable to the people that are using them, but that they eliminate the potential for litigation as much as possible. And when you make it so someone can cancel in their sole discretion, it eliminates a lot of the need for, did you have the right to, what was your real reason to, things like that. Because once it's your sole discretion, you're eliminating that. And this is not only in their sole discretion, but it's in their sole discretion if they are not satisfied with replacement property or have not secured it. By secured it, we mean you've gone under contract to purchase it. And so if they just decide, and really it's because in the contract that they've entered into to potentially purchase a property, it's in their sole discretion, they can decide whether or not the due diligence are acceptable to them. If they're not satisfied with that property, they can walk away, they can cancel. So really, unless they actually are under contract and have cleared all of their contingencies, they're going to have the ability to cancel this contract up until the replacement property deadline. And the buyer is going to have to be okay with that. And so there's things that a buyer can do to sort of mitigate that the risk they have in moving forward with the property. But when there's so little inventory, this type of a form not only protects the seller, but it's probably going to be something that most buyers will agree to, because there just isn't a lot of other properties out there that is the property that they want, like this one. And so they're probably going to agree to these terms because there's 10 other offers that have been submitted as well, and they're trying to win in a multiple offer situation. So we anticipate this form is going to get used a lot. And hopefully what it will do is it'll give listing agents the ability to encourage sellers to get on the market, because that's the only way we're really going to be able to fix this inventory problem, is if we can convince sellers, hey, it's a great time to sell, and we have the ability to actually make it so if you can't find a property to move into or to purchase, we'll be able to get you out of any contract. So it eliminates some of the risk and fear that goes into that. And hopefully listing agents will be able to look at this, understand it, and know how to use it both in practice, but also just in a listing presentation.
Yeah, exactly. So it's in essence a unilateral right to cancel. And you'll notice in 1C, if the seller goes past the replacement property deadline, so they're satisfied with their replacement property, or they're okay moving forward under the REPC, then there isn't a right to cancel after they pass that replacement property deadline. So if a seller attempts to do so once that has passed, then section 16.2 potentially comes into play for a seller default. So there's some commentary. I mean, I would expect that there may be some opinions on this form of when to use it and how to use it. I don't see this being a form that has to be in every contract. I kind of want to reiterate that. A seller may already have a property in mind, and they're fine moving forward, and they just want to renegotiate other terms. Great. I mean, it's all a point of negotiation, and frankly, any contract that a buyer and seller enters into, one is negotiated, and then two, it's a risk analysis for both sides. It's a risk for the seller in analyzing whether or not the buyer can truly perform under the contract, and then if this form is used, it's a risk analysis for the buyer to go under contract with that particular seller for that particular property. So just wanted to highlight that. It looks like there's some questions about a notice form related to this addendum. I think that's probably in reference to section 1A, where the seller can simply give notice. Right now, we don't have a notice form, but we certainly could. I think an easy way to address that, at least initially, would be to just have an addendum. I can't imagine a buyer would object to a seller removing this replacement property deadline or condition. I mean,
I agree with that. I'm not sure you're going to need a notice form when it comes to that, because the buyer is going to be ecstatic when this gets removed. I've used a form similar to this at my brokerage, and I have seen where buyers may trigger deadlines off of the removal of a contingency. And so they may start their due diligence upon this type of contingency being removed. But again, I think an addendum works really well for that, because then you can actually put in the new due diligence deadline based upon the notice being given, and then the parties are going to agree to that, and you've laid it out in the contract. So I don't anticipate us creating a notice form. Craig, you and Lance may weigh in on this, but I think anytime you're going to be giving notice of removing this, it's probably going to be because you're triggering some other provision in the contract, and you're going to want an addendum anyway to deal with it.
Right. And my guess is that point, the seller could negotiate some additional terms, which would have to be agreed to by the buyer at that point. So excellent. As far as section B, it also for notice to cancel though. So I guess there was a question about the notice that a seller would need to give to cancel. And we do have a notice form for a seller's right to cancel. So I would use that. That's already in place if a seller is going to provide notice. And I think the key point, whenever we reference written notice in any of our addenda, we're referring back to section 18 of the real estate purchase contract, which defines what notice must have. Simply needs to be in writing, needs to be signed by the party giving notice, and then it needs to be received by the other side. So I would just use the seller's notice of cancellation form in conjunction with this if a seller is going to cancel.
Yeah, I agree with that. I don't know if we have a box on there for this contingency, but I think there's a box for other that you can actually put that in. And I mean, we may want to modify that in the future, the seller's notice of cancellation, to include this if it's getting used a lot.
Yeah, I agree. So excellent. I mean, as part of the feedback, we're really appreciative of all the forms committee members and everything that they do. We certainly discussed other forms, and we'll probably have Shane come back to discuss those. Just as a teaser, we discussed a referral agreement, so a brokerage referral agreement. We know a lot of brokerages already have their own, but we certainly wanted to create a UAR version. Escrow instructions. So to modify the BAC, how do you mutually modify the BAC? Well, you need to do so in writing, and we're looking at ways to do that. So hopefully that'll be a form that's addressed sooner rather than later. And there's some others. I mean, we're always looking at forms. We're always looking at updating forms. If you have any sort of suggestions, feel free to call me, call Lance, shoot us an email or comment on our Facebook page, and we're more than happy to address those and discuss those. These forms are available on the MLS. They have been sent to all of our forms vendors. Depending on the vendor, it could take a couple of days to a couple of weeks to have these forms available, but they should be available pretty quickly. They are available on our website right now. So you can access at least the PDF version on the UAR's website. Well, I think I mean, we had some other things that we could cover, but we spent a lot of time on that. And I think this is a great video to introduce these two forms updates. Anything you want to add, Lance or Shane?
I just want to thank Shane. He's a great asset to the industry. So thanks for coming on, Shane.
Love you, Lance.
Well, I echo that. Thanks a lot, Shane, for all your work. We know that you're a busy man, so we appreciate you spending some time with us. And thank you everyone for joining us. I mean, it was well attended. It looks like a lot of people have commented. And again, you can call the UAR's legal hotline or comment on our Facebook page, and we're happy to address any sort of lingering questions you may have. So we appreciate you. Hope everyone's staying safe, and let us know if there's anything we can do for you. Until next time, take care.